Hey everybody, Justin Stivers, owner of the Probate Law Firm here, answering a question that we get a lot having to do with a will. So you guys are probably familiar, I talk a lot about it and they're just kind of common knowledge, but a will or a last will and testament is a document that either you prepare, an attorney prepares, or you can get off, one of these websites like LegalZoom or something like that if you're a do-it-yourselfer type of person. And it basically says who's going to get what of your stuff after you pass away. So a lot of times someone will say, I want my wife to get this, I want my son to get this, or my daughter to get this, and whatnot. So it's just a document that says who's going to get what after you pass away. What a lot of people don't know, though, is that having a will, just having a will by itself, generally does not avoid the probate process. So actually, if you were to see here on my business card, I'm not sure how it's going to show up, but across the top, I have here, did you know that having a will does not avoid probate? Because that's one of the biggest misconceptions. I'll get a client who comes to me and they'll say, my dad left me a piece of property. I went to the county, I tried to get the property put in my name, and they said I need to go see a probate attorney and I've got to do a probate. And they're a little angry, upset or whatnot. And I say, unfortunately, yeah, that's true. We're going to have to do a probate. So if a person has a will, generally they're still going to have to do a probate if there are assets that need to be transferred, that the title needs to be transferred. So I talk in other videos, but probably the most common is property, is real estate. So if you've got a piece of property, let's say your dad owned it and it was just in his name, but he has a will and it leaves the property to you, chances are you're going to have to do a probate in order to get that property into your name. Now if he's changed the title somehow, if the title has you on there, then you're probably not going to have to do a probate. But if someone just owns a piece of property and it's in their name only, we're going to have to take that will, we're going to have to show it to the court, show it to the judge, and at the end of that probate process, the judge is going to name you the owner. Same with bank accounts. Those are another pretty common one where, let's say mom had some money in a Chase bank account somewhere, and she's the only one on the account. Because remember, if you're on the account, you can go access that money, or if you're named as the beneficiary, that doesn't matter. But if she's the only one on that account, but she's got a will and it says that you're going, she wants to leave you whatever she had in that Chase bank account, unfortunately, you can't just go to Chase with the will and they're not going to release the money to you. You're going to have to go to an attorney, go through the entire probate process, and there's some steps in between, and we'll be able to get that money from Chase for you. So, big takeaway here is wills are good. They do serve a purpose, but if one of your purposes is that so that your family can avoid going through the probate process, then we probably need to do a couple other things as well. Maybe changing title, adding beneficiary. We may consider doing a trust. So there's other things, that we might want to consider. So, again, there's a lot of information out there. Wills, you can get them, do them yourself, which they're not necessarily bad, but you need to go into it knowing that it's most likely not going to avoid the probate process. So hope you guys found that useful. If you have any other questions, 305-456-3255, or visit us on our website, probatefirm.com, and happy to chat with you guys and answer any questions you guys might have. Talk to you soon.